Imagine failing your high school diploma by just 0.05 of a point. Not half a point, but 1/10 of half a point. Would you accept that outcome, or would you choose to fight it out in court? That's exactly what happened in this case. And by the way, this case appears very similar to another case that I previously covered, but it is actually quite different, and the outcome is completely the opposite. Let's unpack this one. First, I will present you with the key facts of this case and then offer my analysis. In May of 2017, a pre-university high school student in Breda, the Netherlands, took her French exam as part of her high school graduation examination. On one specific question, question number 15, she gave an answer which was marked as incorrect following the official grading guidelines at the time. And that meant she received no points for that specific question. Later, after the exam had been graded, the College voor Toetsen en Examens, the National Exam Authority of the Netherlands, acknowledged that that specific answer which this student gave, which a number of other students also gave, could also be considered a correct answer. But by then, it was too late to change the grading guidelines because the grading had been completed. So instead of regrading all the exams and awarding points individually to students who gave this extra correct answer, the National Exam Authority compensated all the students who took the French exam that year by adjusting the so-called N-term, the national scaling factor used to balance exam difficulty. They raised the N-term by 0.1, thereby giving everybody a little bit of a bonus in their final grade. In other words, this shifted everyone's grade slightly upward. After this adjustment, our student from Breda ended up with a 4.0 on her French exam, but she argued that if her answer had been correctly graded and credited, her exam score would have been 4.1. Combined with her earlier study results at school, that would have brought her final French grade to 5.5. But because she actually received a 4.0 on the exam, her final average for French came out to be 5.45. And this tiny difference, just 0.05, decided everything. Under the national exam regulations of the Netherlands, 5.45 would get rounded down to a 5, a failing grade, but a 5.50 would have been rounded up to a 6, and she would have earned her pre-university high school diploma, so she went to court. And here is the court's decision. On the 28th of August 2017, the Utrecht District Court issued its ruling. The judge openly recognized how extremely bitter it is to fail by such a small margin. The court even admitted that it was theoretically possible that this student had been disadvantaged since her grade ended up a 4.0 instead of a 4.1. But the judge concluded that this did not amount to anything unlawful because the school and the National Exam Authority had applied the regulations correctly. Why? Because the Dutch exam regulations explicitly state that when an error is discovered after grading, you cannot go back and regrade thousands of exams. Instead, compensation must be applied to the whole group by adjusting the N-term. And that's exactly what was done here. The N-term was raised by 0.1. The student argued that if her answer had been credited, her exam grade would have been a 4.1 instead of a 4.0, and this led to a crucial difference in her final grade. The judge acknowledged that this was theoretically possible, but it was not for certain. The court explained that if many other students had also given this additional correct answer, then regrading everybody's exam would have made the exam seem easier overall. So the N-term would have been lowered because there were so many extra people who also answered that question correctly. In that scenario, her grade might still have ended up a 4.0 anyway. And because it was impossible to regrade thousands of exams to know for certain, the court held that the situation, according to relevant regulations, required a collective solution through the N-term adjustment, which was exactly what occurred in this case. So in the end, ultimately, her claim was rejected by the court, and moreover, she was ordered to pay more than 1,400 euros in legal costs. Let's now move on to my analysis, which is just my opinion. There are a few points from this case that I think are noteworthy. First and foremost, this case really illustrates the tension between collective fairness and individual fairness. The exam authority chose to compensate all the students collectively, according to the regulations, by adjusting the end term instead of regrading every single exam. For the group, that may have been the only practical and generally fair solution. But for this one specific student, from her perspective, the outcome was unfair and devastating. She missed her diploma by just 0.05 of a point. For most other students who took the French exam, this group adjustment, although perhaps not perfect, but it was fair enough. Look, if you have already passed, then this slight upward adjustment is just perfectly fine. If you are far below the cutoff point, then this wouldn't matter either, because you would not be able to pass anyway. But for this student, she was right on the edge, where a tiny fraction made the difference between graduating and not graduating. So from her perspective, this collective fix was simply unfair because it erased the very margin that would have allowed her to graduate. So what is fair for the whole group could be unfair to a specific individual. Second, this case also illustrates the tension between practical feasibility and absolute fairness. Regrading the thousands of exam papers to credit this additional correct answer would have been the most fair thing to do, but it was not feasible. The end term adjustment was the only practical solution, and it was lawful. But lawful and practical may not always be the same as absolutely fair. And here, to this specific student, that gap is painfully clear. Basically, she was just unlucky. In a system which was designed for standardization, efficiency, and consistency, she turned out to be the unique, special, borderline individual case that happened to end up right at the cutoff. It's just that unfortunate. Finally, the contrast between this case and the 2025 Lazar case is striking. In Lazar's case, a Dutch high school student failed his diploma by just 0.1 of a point and sued his school over procedural flaws in his appeal. In that case, the court found the procedure to be evidently careless and stepped in to award the diploma. But in this Breda student's case, the court took the opposite stance. It sympathized, admitted the outcome was extremely bitter for the student, yet still concluded that rules are rules, and in this case, the rules had been correctly followed. In Lazar's case, the court intervened because the school had bent the rules in a way that disadvantaged the student. Here, the court would not bend the rules themselves in order to help this student. And from a legal perspective, that was both understandable and consistent, even if, from this Breda student's perspective, it might feel terribly unfair. Also important to note, in my opinion, in the Lazar case, the student sued the school board because of appeal procedural issues. In this Breda student's case, she sued the National Examination Authority. One could argue that this was a tougher mountain to climb because she was challenging not just one particular school's procedures and practices, she was challenging the national system itself, which wouldn't have been easy. So these are my thoughts and analysis on this 2017 Breda high school students case. On my channel and specifically in this playlist, we will cover more cases involving academic misconduct, academic disputes and lawsuits, and other higher education controversies. If you find these topics interesting, please stay tuned. I invite you to leave your thoughts and comments about this case down below. Thanks for watching this Ranywayz random video. Please like and subscribe, and I'll see you next time.